accusatory. A pimp, not a simp. A pimp, not a simp. A pimp, not a simp. We eat so many shrimp. I got iodine poisoning.
Hello. Hey guys, what's going on? Happy Tuesday. May the 4th be with you. I am sufficiently clothed in my Star Wars tie and Stormtrooper Cowboys hat. But, good evening, everyone. Tonight, as promised, we're going to take a look at Juan Galt's latest videos. The two of them are a Russian immigrant who's in New York who fell into the Mark Stevens rabbit hole and tries his luck out in the New York court system. So, without delaying anymore, hello everybody in the chat. Welcome, Doug, Randy, Wazoo, John, Sean, Nada, Dark, John, Other John, Prestonic, Internet God, KIC, Marv, Whiptech. All right, Agent, let's get this show on the road. What's up, Pat?
Well, Mr.
Celine
Medvedev is back. He's our Russian-born sovereign citizen,
Oh,
and he's getting his day in
there we go.
his trial. He has a very simple case. He's excited for
Revenge, motherfuckers! Ryan just donated $20. Can I sue Subway for not offering meatball marinara subs here in Sweden? No.
tinted windows and no
Thank you very much for the $20 tip. $20 tip, man.
Medvedev has been indoctrinated by Marc Stevens.
His name is Medvedev.
And he's going to try to complicate this simple traffic infractions into a federal case. I think you'll enjoy the interaction and the points that he brings up. He tries to follow the script. You'll probably be very familiar with all these tactics. So sit back, relax, and enjoy.
Broadcaster, people be art of Medvedev.
You, Mr. Medvedev?
I'm here on that matter.
Well, either you're his representative or you're himself.
Whiptech, this is the trial itself. The earlier video was the arraignment that I think I already covered before. So we are at the trial itself.
I'm Archie Medvedev. I'm here on the matter on my special appearance.
Okay.
Up.
This is a trial. There are two tickets, both equipment violations. Ticket ending 266 is allegedly a violation of section 375.34 of the motor vehicle law, and the other ticket ending 292.
I'm wearing a what?
A violation 375.12 relates to front driver and passenger windows being allegedly tinted, and the first ticket for a rear reverse light out, and this all refers to 2007 Chrysler. Okay, we're going to have the officer testify. I might as well do this at the same time. Do each of you swear or affirm that what you're about to say in court is the truth?
I do.
Sir?
I don't swear.
I didn't ask. I said you can affirm.
Affirm? Oh, yes, I'm sorry.
I don't swear.
Yes. Before we start, I'm not ready yet. I have...
Adam, if I was able to find any, I would have gotten some Star Wars themed beer.
a couple of issues here. And I was bringing these issues up before Judge Freya. And she still set the matter for trial. However, first of all, I didn't have any information about who was presenting this case. I had multiple people presenting all kinds of information about this case, besides Officer Danette, who is original witness in this case and complaint.
What is your motion?
Oh, I mean, I filed motions.
I read your motions. Apparently, Judge Freya's indication on June 4th was that the motion was improperly filed. The suspension date was June 11th, but she lifted the suspension as a courtesy and scheduled you to come in for a pretrial conference, which appeared.
I'm sorry.
May have taken place on June 17th. Were you here on that day?
Yes, sir, but I'm trying to get clarification on what you just said.
I'm
I'm
reading the judge's notes. 6/4/14 motion was not properly filed. Suspension date was going to be June 11th, but she lifted that as a courtesy and scheduled you for a pretrial conference on the 17th. It appears that on the 17th, you requested a trial.
No, I did not request a trial. Here's the issue. The issue is that I have responded on 2013, and it was November 6th, to these allegations. Now, it was ignored.
I'm sorry, in what way did you respond?
You should have
Your motion?
you should have a affidavit of status.
I know I have two copies of it.
Yes.
I've read it.
And it's stamped by the court on November 6, 2013. Then my second response was,
But I'm not sure what relief you seek as a result of that.
or relief. Well, I was supposed to respond, so I made a response, and I don't know why and on whose authority my information was sent to the Department of Motor Vehicles. And then I had to make a second response again, now through motions and directly to the complainant.
Just for those unaware, the original charge, if he hadn't already said, it was for the window tint. I think that was the charge here.
And filed with the court. And then now you're saying that Judge Freya said that it was not properly filed. So can I please get a clarification of what was not properly done with my motions, which is...
I have no indication. I can come up with a couple of reasons right off the bat. Number one is that it doesn't appear to have been served.
New York State. I don't know what part of New York, to be honest.
Served, I'm sorry, to who?
Certificate of service? I see that.
Okay.
No, take that back. Appears to have been served. It's not clear to me what your relief request is. Usually in a motion, you're asking for something. What are you asking for?
Well, I mean, it clearly says that.
Statements.
Okay.
You say, as you said today, that you're looking at spatial appearance and not for the court's jurisdiction. I got that. And then there's a lot of language about what courts can or cannot do. And then you make a conclusion statement that the plaintiff has failed to allege the required elements of the cause of action.
Cause of action. If you guys have that in your cards.
Crime. And the court has done to
Hey, Gail. Hey, Randy. In every state, it differs between every state, but it's usually at the discretion of the court. But but as you can see, it's yet another clandestine recording.
If that hasn't been ruled on thus far, I'll rule on it now. It's denied.
You deny the motion
That's what I just said.
to strike and dismiss. I'm sorry, on the grounds of what?
On the grounds that you don't tell me why it should be.
Okay. The motion to strike and dismiss. I'm sorry, on the grounds of what?
On the grounds that you don't tell me why it should be.
On the grounds that you don't tell me why it should be. You don't explain why I should grant your motion.
Okay.
I mean, I don't see that there's any technical basis with respect to the complaint, which in this case are the tickets. Why it's not correct. I'll let you.
I mean, I requested, I made a second motion for discovery that was not even responded to me by anyone.
Okay.
Uh,
Generally, this is not something that's done in court.
well, but with all due respect, objection. This is a matter of jurisdiction in the first place. It says in my motion for discovery,
Right.
and my first.
Okay, here's what you're going to hear a lot of, the word objection. This guy's been taught by Marc Stevens that everything that comes out of the judge's mouth is a lie, and therefore you should object to everything, because he convinces them that it preserves the issue for appeal. It's really kind of dumb, but hang on, you're going to hear more of it.
Motion as well.
If you look at the tickets, and you look at the information you're requesting, it's pretty clear, it's clear enough to me, that you were in the state of New York when this occurred, that you were present in the citywide plans when this allegedly occurred, that you're subject to the laws of the state of New York, particularly by your voluntary, it's been often said that.
Objection, Judge.
I apologize for that, Cygnus. It's just like the judge's voice is pretty low, but if I raise the volume, you're just gonna get blasted by the soft-sit.
But
You can object, but it's often been said that with respect to driving, that you don't have a right to drive. It's a privilege to drive that's granted you by the state and by their issuance of licenses and registrations and things of that nature. So you subject yourself to the laws of the state of New York when you decide to drive.
So what the judge is saying is that when you decided to get behind the wheel of a car and get a license to drive, you subjected to yourself to the laws of the state of New York.
objection.
The valid cause of action is listed on each of the tickets. The specific violation section is noted on each ticket. An explanation of it is noted on each ticket. So I'm not sure why you're saying that.
Objection. The burden of proof is not on you, Judge. It's on the prosecutor or the one who's bringing the complaint against me.
Forgive me, but I'm the one who decides your motion.
Exactly.
Yeah, you deciding my
I'm
motion.
deciding your motion.
That
I'm not finding you guilty. I'm deciding your motion.
yes, sir. But in my motion, it clearly states that I'm asking for evidence of jurisdiction.
Evidence of jurisdiction.
Bingo, there it is. Jurisdiction, evidence of jurisdiction. That's what he's looking for. He's going to be given and has been given evidence of jurisdiction, but he gets so wrapped up in his own mind and his paperwork, he doesn't recognize the evidence when it's given, which is typical of a Marc Stevens acolyte. Let's continue.
Applicability of code and laws, whatever you just cited that you alleging me. Oh, I mean, sorry, Mr. Danette alleged me in violating, and that's the main point I wanted to put everybody's attention to.
What is your basis for saying that the court lacks jurisdiction over traffic matters?
I haven't provided any evidence of this being applicable to me in the first place. I'm looking for facts, not hearsay.
Drive?
I'm sorry?
Do you drive?
Well, now you're making discovery questions.
Huh?
Well, if you weren't driving, you're not guilty. That's for sure. If you do drive, you're subjecting your own self to the laws of the state of New York by going to motor vehicles and getting a license and registering the vehicle. It has license plates on it. You have subjected yourself to the traffic laws of the state of New York when you've done that.
Objection. That's not an evidence. I don't see any.
There's nothing from me that I said that you can object to. You can disagree with it, but you can't object to it.
Exactly. The judge put it in plain English right then and there, and the discussion should have ended at that point. But as we all know, it's not going to end at that point.
Sir, again, with all the respect,
You are free to appeal my rulings.
I'm looking for facts. I'm not looking for hearsay, and I'm not looking on assumption, because assumption is not evidence.
What kind of facts are you looking for?
facts.
Hey,
I
Thomas.
said everything in my motion. The facts of code and laws being applicable in the first place, and
I'll count that as statutes and codes.
I really had a lot of time. I was waiting for a lot of time to get that factual
Are you
information.
really saying that you're not familiar with the vehicle and traffic laws of the state of New York, that they exist?
Objection. This is irrelevant.
It's completely relevant. You're charged under the vehicle and traffic law of the state of New York.
Sir, are you assuming the burden of proof on the behalf of the plaintiff?
As I told you, I'm making.
I mean,
Now, this is what Stevens has also taught them to say. It's when the judge makes a ruling, you're supposed to accuse him of taking up the burden of the prosecution. It makes no sense in the real world, but in the fantasy world of
I think he did too, Gary.
it makes sense. Let's continue.
Ruling, I'm not assuming any burden of proof. The burden of proof is on people to prove the alleged offenses, but you're asking me to prove that the court has jurisdiction in the first place.
No, sir. I'm not asking you to prove to me that
Let's move forward.
Sir, objection. Are you relying on any facts of evidence that the people provided you with that
No,
it's applicable?
An accusatory instrument. The facts and proof come at a trial.
Are you saying that the accusatory instrument is a proof of jurisdiction?
I'm saying that the accusatory instruments meet with the Department of Motor Vehicles rules, and they meet with, as far as I can tell, proper notice to you of what the offenses are alleged to have been, where they occurred, who they occurred to, who was present when it occurred, what city it was in, what state it was in, what particular section of the vehicle and traffic law was allegedly offended, what time it occurred. Yes, I found these jurisdictionally correct.
Exactly.
Okay, the judge just laid out the accusatory instrument, which is the traffic citation. And he laid out all the alleged facts that, of course, will be proven at trial, and all the alleged circumstances. And what that does is that establishes a prima facie case. And the judge looks at that prima facie evidence, assumes that it's true, takes it at the best light that it's true, and that now the Mr. Medvedev has the burden to prove it false, to rebut it. In other words, the prima facie evidence establishes a rebuttable presumption of jurisdiction and truth. It's a rebuttable presumption. In other words, Mr. Medvedev has to rebut it. Let's continue.
Can you show me any?
And to add on to what Juan Galt says, which, by the way, the videos in question are in the link in the description below. Again, shout out to Juan Galt for the uploads. Again, the links to the videos that I'm looking at are in the description below. So check those out. Check him out. Please sub to him if you want to know more about the BS that is spewed from Marc Stevens' mouth. So shout out to you, Juan.
Evidence of that.
I don't need to. I've made a ruling.
You made a ruling. You made a ruling, and you assumed the evidence on behalf of the plaintiff. Is that correct?
I'm not assuming anything. I'm saying that it's jurisdictionally proper. Now we can go on with the proof and evidence.
Am I entitled to see evidence before in any proceedings
Sure. Is there
against
any
me?
evidence other than testimony?
I need it.
Pardon? Are there any photographs or videos?
Evidence of jurisdiction, which I
We're past that, sir. I'm not going to go over this again for the 5th time.
objection will be.
Well, now we're at this again 5 times, and the judge pretty much made it final just now. But unfortunately, he's going to continue on with this shit.
Issue is not going to go away. I'm going to bring it every step of the way.
See?
Sir,
There he goes.
Hey, stay safe out there, Deacon. I know down in the south, y'all are dealing with some nasty thunderstorms and tornadoes. I saw what happened last night, so, you know, obviously, you know, stay safe down there.
And believe me, he does. And the judge doesn't care for it. Stay tuned.
I'm going to tell you right now.
Yes.
If you tell me there's no evidence of jurisdiction again, I'm going to hold you in contempt of court. You've made your point 5 times. Don't waste everyone's time. You may appeal my ruling, but that's your option. But it's not proper to make the same legal motion 5 times in 10 minutes. I've heard you. I disagree with you. It's your right to make the motion. It's my job to make a ruling on the motion. I've made a ruling. Let's move forward.
The threat of contempt of the court is going to be ground for an appeal.
See, he's been taught that everything is grounds for appeal.
All I'm saying to you is don't repeat yourself. I've heard you 5 times on the same issue.
So I'm being alleged of something that there's no evidence of.
Well, how do you know that until we've had a trial?
Because this is not a trial evidence. Jurisdiction is not a trial issue. I can bring it in.
That's another thing Mark Stevens pounds into their head. To always say that jurisdiction is not a trial issue. Well, yes, you can challenge jurisdiction at any time. But once that challenge is made, you either have to bring forth evidence for it or it has to be handled at trial.
Anytime.
You've brought it 5 times today.
I brought it.
You brought it in your motion papers.
Yes, sir. I brought it. Yes, exactly.
Okay.
Way before today. Way before even my first appearance
Okay, so
in front of.
what do you expect would have happened with your claim? What?
My claim.
Yeah, your claim that the court doesn't have jurisdiction.
I'm not making any claims yet. I'm just.
That's another thing Stevens always tells them to say. Don't ever make a claim. Don't ever say you're making a claim. Just say you're, making or requesting clarifications, which in essence, of course, is asking a question.
Objecting.
Proof of jurisdiction.
Again, I'm not asking you for proof. I'm asking for what you rely on in making, on what evidence do you rely on in making that ruling.
What do you mean by evidence?
And he's given him that answer. He went through the whole list of things that's in the accusatory instrument, the traffic ticket, and that is prima facie evidence that
Ad nauseum.
rebuttable presumption.
I need factual evidence that of jurisdiction because this is an essential element of any allegation.
Okay, now we're past that. Now you've raised it for the 6th time. You want to go for 7?
Ha!
Sir, I pretty much said everything about the jurisdictional
So
issue.
let's say something about something else then.
That's nothing really to say too much about because, the main reason why I was coerced into coming here today and, it's not resolved.
What do you mean coerced?
Well,
You responded to a summons.
yeah, what would have happened if I didn't come here today?
The license probably would have been suspended.
And then what?
And it will be up to you whether to respond to that.
Okay, see? That's how I'm coerced.
Yeah, okay, enough.
He's like, okay, yeah, all right, we're done. We're done here.
People ready to proceed?
Yes, sir.
People are required to provide some testimony and/or evidence. Do you need to refer to the tickets?
Yes, sir.
All right, first put your name, your number, etc. on the record.
Officer Robert Denay, shield number 11, ID number 1932, the White Plains Police Department. Patrol unit.
Okay. Do you recall this incident?
Yes, Your Honor.
Can you tell the court what happened?
Absolutely, Your Honor. Your Honor, on October 22nd, around 12:47 p.m., I was on patrol in front of the area of 244 Main Street, which is directly across from 275 Main Street, the Walmart, just to give a more
Can you run
perspective.
that by me again? please?
Sure.
You were at 244,
I was in front of 275 Main Street.
and that is Walmart?
That is Walmart, just to give you a reference. At that location, I was conducting traffic enforcement on the taxi lane,
Which is on the Walmart?
which is on the Walmart side.
Hold on. I want to. I don't know what they said when if they mentioned the location. Hang on.
Control unit.
Okay. Do you recall this incident?
Yeah, what would have happened?
That?
Okay, see, I mean, that's how I'm correct.
People are required to provide some testimony and/or evidence. Do you need to refer the tickets?
Yes, ma'am.
All right, first put your name, your number, et cetera, on the record.
Officer Robert Denay, shield number 11, ID number 1932, the White Plains Police Department.
White Plains. That. Yeah, that explains. That explains it.
44,
I was in front of 275 Main Street.
and that is Walmart?
That is Walmart, just to give you a reference. At that location, I was conducting traffic enforcement on the taxi lane,
Which is on the Walmart?
which is on the Walmart side.
Right.
At which time I observed the defendant here operating a 2007 black Chrysler across the street, double parked, in front of 244 Main Street.
Where's that in relation to?
That is
Five
the
Guys?
last store on the same side of Five Guys. I believe that's the Citibank there, just before the construction area.
Okay.
Yep.
So directly across from Walmart.
Directly across from Walmart.
And when you say double park, what do you mean?
He was double parked, blocking lane of traffic.
Okay.
I approached the driver, Mr. Try to pronounce the name. I'm sorry?
Medvedev.
Medvedev. I approached the driver's side window, at which time was rolled down, and Mr. Medvedev was operating the vehicle at the time. I advised him he was double parked and he needed to move his vehicle. Proceeded to ask me where he should go, that he was waiting for a client, which I would assume he was a livery cab or a taxi cab of some sort. He did in fact produce a hack license, I believe to Westchester County hack license. I advised him I can't give him that information, but where he was unsafe and he needed to move his vehicle. He continued to argue with me. I advised him if he failed to move his vehicle, I'd have
Okay, I know Mark Stevens doesn't adhere to this, right? But if you just heard him, if you heard what he just said right there, again, I know Mark Stevens doesn't adhere to this line when it comes to right to travel. But he just mentioned that Medvedev was operating what may have been a cab. So he was operating in possibly a commercial capacity when he was stopped by the cop.
issuing the summons for being double parked. As I started to hold up traffic so he can back up because he was in the construction lane blocked off by cones, he proceeded to reverse his vehicle and roll up his window, which I could see that the reverse light was out and he also had tinted windows. He proceeded to pull into a parking space, which was not a parking space. It was actually a bag with a meter bag stating no parking.
Where was that?
That was just right in front of 244 Main Street.
Which
Again was in
Citibank?
front of Citibank, correct. Again, once he was out of traffic safely, I approached the driver. He rolled down his window. I requested his driver's license and registration. He asked me what for. I advised him that his reverse light was out, as well as he had front driver and passenger side windows tinted, which were.
Oh my God, Deacon, I really hope that you have moved yourself into the basement at this point, and you're just watching the stream on your phone. But for the love of God, I hope that you're in a safe spot at this moment.
Point that I could not see the driver on the side of his windows. He produced them. Another officer appeared, Officer Marc, as a secondary unit when I called out on the traffic stop. 2 summonses were issued to Mr. Medvedev, and the subject went on his way from there.
So do you have any questions relative to the testimony that you'd like to ask?
Yes, I would like to cross-examine the witness.
Point. Go right ahead.
Okay, good.
Okay, here's where it's Mr. Medvedev gets his chance, and you're going to find this interesting. It'll be a little short intro here, and we'll pick it up in the next part, his total cross-examination.
All right, we are now getting there.
Do you have personal knowledge of these facts?
Yes.
What, that he stopped you? God, I hope so.
How so?
I just produced them to the court.
Just because you
What do you...
produced them to the court, you have a knowledge of them? Did anybody supply that information to you?
That's what he said, personal knowledge. As I take the testimony of Mr. Medvedev, I believe this officer was present and interacted with you.
Sir, I hold due respect, but you're not his attorney.
Well, you're treading thin ice right now, buddy.
Woo!
Sir, I hold due respect, but you're not his attorney.
Well, you're treading thin ice right now, buddy.
You're treading thin ice right now, buddy.
Don't tell me what to do in my own court.
I'm not telling you what to do. You're just leading him into answering the question.
I'm not leading him. I'm saying that I heard the testimony as meaning that he was physically present and had personal knowledge of the interaction with you. So you're wasting my time by asking what his basis was for making these statements. He was there. Okay, let's move on.
Objection. I'm not asking
I'm
you.
not asking you to object, sir. We went through that already, too. Now, if you want to conduct yourself as an attorney, then conduct yourself as an attorney. I'll be glad to hear relevant questions regarding the testimony. But if he said he was there and had personal knowledge, don't ask how. Continue.
Are you here today voluntarily?
Yes, sir.
Okay. So you're stating you were not forced in here today. So nobody, no prosecutor, no judge forced you to come in here today.
No, sir.
Are you testifying because you want to testify today against me in these proceedings?
I'm testifying on behalf of that's part of my job.
Are you relying completely on your testimony to prove every element of the crime you charged me with?
I'm sorry, can you repeat that?
Are you completely relying on your testimony to prove every element of the crime you're charging me with? Are you competent and credible to prove beyond a reasonable doubt the code is applicable to me and I violated it?
You don't have to answer that.
Objection.
Credibility.
You charging me with?
Hold on.
Are you competent and credible to prove beyond a reasonable doubt the code is applicable to me and I violated it?
Raw, he cannot answer that. He cannot. He's asking him to make a legal conclusion. Are you competent here today to prove beyond a reasonable doubt that I violated the law and that I am applicable to it? It's raw that he cannot. The cop can, as Juan Galt will, I imagine he'll say it again. The cop can make a legal determination that I saw this guy speeding and committed a traffic violation, but the cop cannot conclude that. That's not up to the cop. It's up to the judge and or jury to make that determination.
You don't have to answer that.
Objection.
Credibility is my
Exactly.
determination, not the officer's own determination of his own truthfulness. It's up to me to assess the credibility of witnesses.
I object to that. You have personal knowledge of the facts proving the laws and code are applicable to me?
Yes, the summons that was issued to you.
Were you coached and prepped in any way for your testimony today?
No,
So no one spoke to you before today about your testimony?
correct.
Are you an honest man? Objection.
Again, it's up to me to determine the truth, the veracity of the witnesses.
Maybe you'd like to tell me the grounds on which you not letting him answer my questions.
First of all, it's irrelevant what he thinks of himself.
Exactly.
We don't really
Anybody could say, "Oh, I'm totally an honest man," but they could also be a lying sack of shit.
even need to get into a philosophical discussion about it because it's not relevant.
So you're also prosecuting me with Mr. Danette, right?
Move on, please, sir.
Ugh.
Don't be.
Well, you're not being responsive to my questions too. Do you always tell the truth?
Yes.
Are you credible people should take your own words? I'm sorry. Are you credible people should take you at your word?
Huh?
I'm sorry, say that again?
Are you credible people should take you at your word?
I would like to think so as a police officer.
So it's a yes or no?
That would have been yes.
Thank you. Do you always tell the truth to your supervisor at work?
Okay, enough of this. Move on to another area, please.
Sir, this is how I'm conducting my cross-examination.
And I'm cutting you off. That's
What the guy is trying to do is he's trying to undermine he's trying to question the cop's credibility. But he's doing it in a fucking asinine way and a completely repetitive way that doesn't get us anywhere. All of these questions that he's asking, the cop can simply say, "Yes, I'm credible. No, I don't lie to my superior." These are questions. These are answers that anybody can fucking answer, even if they have a history of being a lying sack of shit.
On the grounds, please. Tell me the grounds, because I object.
It's not relevant to whether you were parking in reverse without a reverse light. It's not relevant to whether you had tinted windows.
Bear in mind that the judge did allow him to ask several of these credibility questions. But he can't keep on asking the same question in a different way over and over and over without the judge ultimately saying, "Okay, we're done here. Move on."
The officer's credibility, while credibility is always an issue, has been established by you in the preceding questions. In order to ask
Okay, I have not seen the full video from start to finish. So basically, the judge just gave me the answer, gave me the reasoning for me. There you go.
after you've already asked him whether he always tells the truth, now you're asking him, who does he tell the truth to in particular? When you ask the question, sir, do you always tell the truth? That would include always, and for all time and to everyone. So you've already essentially asked that question.
Objection. You're leading.
I'm talking to you.
Yeah, he gets pretty salty there with the judge. And we're going to end it here and pick it up in part 2. It gets really going real good. So I know you're going to enjoy it. Hope you've enjoyed this one. If you haven't, please like and subscribe. And stay tuned for part 2.
Here we go, part 2.
So we continue the trial of Mr. Medvedev. And he continues to be salty with the judge. I think you'll enjoy this. I want you to focus on 3 things, and you can use 2 of them as a drinking game if Artie reviews this video. So anyway, jurisdiction.
I'm feeling kind of called out here, Juan. What are you trying to say to me, man?
Of course. Every time you hear that, take a drink. Objection. I object. I object to that. Drink every time you hear that. And also pay attention to where he keeps asking for evidence that the laws apply in the first place. Now, that is the signature Marc Stevens magical question, they think. They think that there is no evidence that can prove
Debunked and exposed live.
that the laws apply to anyone. So they keep asking that question, what evidence have you seen has been presented that shows or demonstrates or proves that the laws apply to me in the first place? So sit back, relax, and grab your favorite drink and enjoy.
No, you helping the witness right now.
Sir,
I do want to say this about Mr. Medvedev. He really sticks to the Marc Stevens script and tactics better than anyone I've listened to. I mean, he's totally wrong in all his positions, but he does apply the Marc Stevens bullshit as it is taught. So, enjoy.
move on.
Sir, are you on the oath?
Move on.
Sir, you're not being responsive. Are you
I
under
don't
oath?
have to be responsive.
Yes, you do.
Fact finder. No, I don't. I don't have to answer litigants' questions.
Let it be another reason to appeal.
You may appeal.
It is actually pretty good. I would say Bonesaw is a pretty decent local brewery.
As your right, but you may not conduct this courtroom.
Sir, if you want to
No,
prosecute me,
move on.
you can.
You
We
wanna
can.
do th- You want him to do this dance,
Yeah, he asked the judge if he's under oath.
sir?
If I want to do dissent,
Yes. Would you like to?
I don't
would you
understand
like
the question.
to keep talking to me, or would you like to have a trial?
sir, originally there was no evidence of jurisdiction, and I told you I'm
I
gonna.
made my ruling on that.
You made your
Now let's
ruling.
Move on to the trial.
You made your ruling regardless of
You're on
any factual
cross-examination.
evidence.
You're on cross-examination now, so do cross-examination.
I do cross-examination. You keep interrupting me
Sir, you're asking me questions about myself.
because you're not letting me question the witness. You're not letting me cross-examine him.
Have you ever seen a trial before?
How is that relevant?
Because if you had, you would know that judges make rulings on questions. I made my ruling on your question. I said that the question has already been asked by you to this officer and answered in a way that would preclude your asking the other question you asked about whether he was truthful to his supervisor. So I'm making a ruling that you should move on because you do not have the right to ask the same question multiple times.
Sir, am I entitled to a fair trial? Okay, can I get a fair trial as a conflict of interest?
I don't even know what you mean by that.
Oh my fucking god, now he's going into this part of the script. The whole fucking conflict of interest thing.
I'm just asking you.
I don't
It's a
know
yes or
what you
no
mean.
answer. Who do you represent here today in these proceedings?
Seriously?
Sir, I just asked you a question. Who do you represent in these proceedings?
I'm not a representative.
You're not representative. So,
Not in the people of the state against you. I
okay.
am on neither side, if that's your question.
Okay, so what are you doing in these proceedings here
I'm the
today?
judge.
The judge, and what's
Do
the
you know that?
what's the responsibility of a judge?
I'm not further answering your question.
Okay, sir, I am not going to be here and teaching you civics. At this point, we are literally in the middle of a trial. The officer is still sitting on the witness stand at this point while they're having this back and forth.
Sir, this is ridiculous.
Okay.
You can look it up. You can look it up if you need to.
I'm gonna ask you one more time. Are you on the oath right now?
You can look that up too.
So you don't want to respond to my question.
I'm not a witness.
You're the one who's making statements, and you're the one who's assuming burden of proof on the complainant's
We've
behalf.
already been through that, so let's move on.
So you're not going to respond to my
We'll
question?
have the burden of proof. I've told you that. I have responded.
No,
Move on.
I ask you if you're under oath right now.
And I am not getting into philosophical debates with you.
I'm not debating with you, sir, in no way. I'm just asking questions in order to understand these proceedings and the allegations that are being brought up against me.
Now we're reverting back to his arraignment script. Again, we're in the middle of a trial right now. We're in the middle of a fucking cross-examination, and now he's reverting to the bullshit-ass arraignment script that we're way past at this point. And now, if I was the judge, I'd be telling you, dude, you should have gotten a lawyer at this point, because I'm not going to be able to answer those questions for you.
The fact that you're frustrated with my not answering any question you want is of no moment.
I'm sorry, are you saying I'm not allowed to ask you questions?
That's right, I'm saying.
I'm not allowed to ask you
Exactly.
questions.
If it has to do with my evidentiary rulings, fine. If you're not clear about something, fine, I'll answer your question.
Well, that's why I'm asking you a question.
That's not the question you asked. You asked me if I was under oath. What does that have to do with the testimony?
What does that have to do with the testimony?
Yes, I'm not testifying.
Gee, I'm not asking you for evidence, to present evidence against me. You always keep interrupting my cross-examination of the witness.
Because it's asked and answered. They're repetitive at this point. You've already asked questions related to the officer's credibility. And at that point, you kept on asking the same question over and over and over again. And the judge stopped it because it's asinine. We're done. Move on. And you have a problem with it because you don't want this to go through the end of trial because you know you're going to be found guilty.
I'm trying
If
to...
I find the questions improper, I will stop you. Just as if the officer said something that was incorrect or improper, I would stop him too.
See, Stevens doesn't prepare them for moments like this. He tells them, ask questions, ask questions, ask questions, ask questions.
Juan, you know it's not about questions. You know it's points of clarification.
And the bottom line is, the judge just says it, they're not required to answer any of your questions.
Again, are you, do you always tell the truth to your supervisor?
For fuck's sake, he already asked this question.
Sir, when you use the word again, that means you've said it already. Next question.
Are you objecting to my question?
I'm ruling that you cannot ask it.
You're ruling on it.
Yes, sir.
Okay. And the grounds of that ruling?
Because it's been asked and answered already. It's an evidentiary ruling.
I haven't gotten any response.
He said he's truthful all the time.
No, he was answering a different question, sir.
How is this different?
Because I haven't gotten any response on this question.
What was this question?
Do you always tell the truth to your supervisor at work?
And how is that different than always telling the truth?
Exactly! How is that the question that he already answered is not all encompassing? That would also answer the question that he just asked.
That's the way I conduct my cross-examination in order to get evidence that he's relying on.
So you've already asked the question, does he always tell the truth? The answer is yes. That would include a supervisor, that would include you, me, everybody else.
I hate the fact that the judge has to spell it out for him.
That he ever speaks to.
Again, you're leading him.
How is he leading him? He answered the goddamn question!
I've ruled on it twice now. Don't make me rule on it a third time.
Are you prepped or coached to speak to your supervisor?
I'm sorry?
Are you prepped or coached? Are you prepared or coached to speak to your supervisor?
Regarding what?
Regarding any kind of information that you present to him.
And how is that relevant to your traffic ticket, sir?
Sir, the matter is jurisdiction again.
No, it's not. I've ruled on it.
I haven't gotten any evidence of jurisdiction. I haven't gotten any evidence at all.
Again, sir, the fact that you're frustrated by these proceedings is of little moment.
I'm not frustrated. You're just not letting me cross-examine the witness. You haven't told me what evidence you have.
I don't have the evidence. It's the officer's evidence.
So the officer did not provide you with any evidence that he's using against me.
His testimony is evidence!
That's your opinion?
Sir, I mean, I sent a motion for, it was a Brady request and
Would
discovery. I haven't gotten any response. And now I come here today, I was
you
forced.
like a continuance?
Yes, I would like to continue.
Fair enough. And what is it you suppose you could gain by continuance? Because I don't want you to be unprepared for this.
No, I'm getting prepared. The only problem is
So, sir,
today.
Don't speak over the judge, sir.
Now that you've heard the testimony, which is evidence, testimony is evidence. Now that you've heard the testimony and understood that am I correct, officer, that there are no other documents or witnesses to be called in this trial?
That is correct.
If you need a continuance to prepare your cross-examination for what the officer has testified to, I'll grant it to you, because you told me you were not aware necessarily that today was going to be the date for trial. All you have to do is ask.
Sir, I object because the motion for discovery and Brady request was filed enough time in advance.
Right, if you can show me where in the vehicle and traffic law, you get an opportunity for that sort of discovery which you've asked for, I'll be glad to grant your motion.
Sir, you.
See, they're here again. This is something they're not prepared for.
All right, I'm gonna go back 30 seconds to hear what the judge just said. Sorry, I apologize.
No, I'm getting prepared. The only problem is
So, sir,
today.
Don't speak over the judge, sir.
Now that you've heard the testimony, which is evidence, testimony is evidence.
Okay, thank God the judge said
Now
that.
that you've heard the testimony and understood that am I correct, officer, that there are no other documents or witnesses to be called in this trial?
That is correct.
If you need a continuance to prepare your cross-examination for what the officer has testified to, I'll grant it to you, because you told me you were not aware necessarily that today was going to be the date for trial. All you have to do is ask.
Sir, I object because the motion for discovery and Brady request was filed enough time in advance.
Right, if you can show me where in the vehicle and traffic law, you get an opportunity for that sort of discovery which you've asked for, I'll be glad to grant your motion.
Sir, you.
So let me get this straight. The judge, despite this man's disrespect to the judge at this point, the judge says, you know what? I'm willing to grant a continuance at a later date if you want to prepare for your cross-examination better, and or file a motion for discovery, for a Brady discovery, as he puts it, which involves exculpatory evidence, and the judge will hear it. But he says, no, I don't wanna.
See, they're here again. This is something they're not prepared for. Is in many traffic courts, you don't have discovery. So this guy doesn't realize that. He's not prepared for it. And so this is what ensues.
file a motion, specific motion to dismiss, that's fine. But I don't see, let me see the file.
Objection. I haven't seen any evidence.
Stop saying objection to every fucking response you're giving to the judge.
Actual evidence of jurisdiction,
Oh my fucking god, he's still going on with it.
of applicability of the law, court, or what?
To you?
To me, yes, exactly.
Okay, well, that's been ruled on. Now for the fifth, sixth time?
No, Judge, we're at the 7th time, I think.
Ruled
I
on
find
what?
the court has jurisdiction over you. You've subjected yourself to the laws of the state of New York by signing up for a license and a registration.
Can I
You're
see?
using the roads of the state of New York. You were issued a ticket. You came here to answer it voluntarily.
Sir, objection. Is that your arbitrary decision?
It's not, it's hardly arbitrary.
Okay, so what evidence do you rely on? Do you have
Sir.
any evidence? I haven't seen any evidence against
You
me.
don't, and you won't.
Why not? Are you hiding evidence against me?
The only evidence against you does not come from me, sir. That's the point.
Well, who does it come from, sir?
Comes from the prosecution, in this case, the officer. He's testified as to the facts and circumstances of the issuance of the tickets. You're in the middle of cross-examining him, sort of, and I'm just saying right now, if you want to prepare further for that subject matter, the cross-examination of the officer who's provided testimony against you, that's fine. If you'd like to continue, that's fine.
Objection. Nobody had provided me with any evidence.
Okay, he really is starting to trigger me really bad with this repetitiveness.
He doesn't recognize evidence when it's told to him. The judge has told him evidence over and over again, but they're not prepared for these types of situations when they arise because they've been told, you know, in essence, the only evidence that they would accept would be a signed consent form where they have consented to be subjected to these laws.
Exactly. According to the Marc Stevens script, the Marc Stevens ideology, unless I, Artie,
$5 a month.
Melissa, thank you for joining the crew as a sovereign. Much appreciated. And also thank you, Florida IG, with the $5 super chat. Thanks for putting those pulse meter on. I know, by popular demand, I'll put on the freaking heart rate monitor so you could see me have an aneurysm live. But as I was saying, according to Marc Stevens' ideology, unless you can show me signing Artie consents to the laws of the state of New York, then there's no proof whatsoever, period, end of story.
Well, if nothing else, they've given implied consent the minute they get in their car and drive on the public roads.
I haven't seen factual evidence. It's all hearsay.
It's not hearsay. You asked the question whether it was on personal knowledge. So it's not hearsay.
Just, I haven't seen any evidence.
Just because you won't accept it doesn't mean it's not evidence.
I was coerced here to come here for a trial.
If what you want to know is whether there are photographs or documents or things of that nature, there appear not to be.
See, the judge, at this point, with the judge saying that, the judge still doesn't, I don't think the judge has really experienced Marc Stevens' script. So he doesn't quite understand what the guy is trying to get at, which is what we just described. Juan and I just elaborated. That he wants physical evidence, aka a signed signature saying that I consented myself to the laws of the state.
Why was I not presented in timely manner with any information or evidence, and specifically factual evidence, that were supposed to be used against me?
He doesn't realize, it hasn't hit home yet, that the officer's testimony is evidence. Testimony, as well as documents, as well as pictures, as well as all this other stuff, is evidence. It's real simple. They just aren't prepared to understand.
Sir, I've been through your motion. I read through your motion. I made a ruling at the very beginning of this case that all the answers to your questions are contained within the accusatory instrument to the extent that they're proper.
Objection. Where on accusatory instrument it says it shows facts of jurisdiction.
It says that it's issued by the White Plains Police Department. It says that it occurred in the city of White Plains, in the state of New York. The location of the alleged offenses, the time of the alleged offenses,
$5 a month.
Thank you, Brandon Smith, for joining as a sovereign. Much appreciated, man.
of the alleged offense, your name, your ID number, your plate number, the date your registration expires, what the section you're alleged to have violated was, and a written explanation of what that section is. That's a lot of information.
Objection. Is that allegation, those allegations are the proof, a factual proof of jurisdiction?
Sure.
So alleging me of violating a code is in fact a proof of that code applicable to me and gives this court jurisdiction?
Not always, but in this case, yes. That's my ruling.
Okay, another reason to appeal.
Wouldn't be the first time. So do you want to continue with this trial or not?
Sir, I requested, I made a motion for any facts that the prosecution.
Oh my fucking god, he's still going. He's still going. Oh my god.
Lies on against me. I made a Brady request. I was trying to. I was trying to.
He's stuck in a goddamn fucking loop. He's a fucking android stuck in a loop.
Determine what matter was.
What? I'm sorry, I didn't hear.
What matter this was, civil or criminal. I was trying to ask as many questions in order to understand these proceedings as possible. Now I feel that you prosecuting me instead of trying facts.
I'm responsible for your feelings, sir.
And I mean, there were. I feel that
Wait, what did he just say?
you, civil or criminal. I was trying to ask as many questions in order to understand these proceedings as possible. Now I feel that you prosecuting me instead of trying facts.
I'm responsible for your feelings, sir.
And
I'm not responsible for your feelings, sir.
there were a lot of reasons for me to believe that.
Let's do this for just a moment. What is it that's not on the accusatory instruments, two of the tickets, that you need to know in order to have a fair trial?
Sir, objection, but am I presumed innocent? So where can I get and when can I get, because I've been waiting for quite a long time, for the factual evidence, and they all listed right there what I specifically requested.
Apparently, the only evidence is the testimony of the officer.
Okay, but you're not letting me cross-examine the witness too.
I am to the extent that the rules say you're allowed to. The rules of evidence.
Okay, so you said I have a right to fair trial. Is that correct? Okay. How is that this trial was scheduled today on my behalf?
What?
Well, you said the Judge Freya scheduled a trial.
All I know, sir, is that it was scheduled for a trial because you requested one. And apparently, had you provided some proof that the vehicle was repaired, tickets probably would have been dismissed.
Objection. How is that relevant to this matter?
Not relevant to the trial. We're at a trial now, so I'm asking you whether you want to continue.
I will give credit to the judge that he has the patience of a saint at this point. I really don't understand how he hasn't been held in contempt at this point.
Motion to dismiss for lack of jurisdiction and evidence.
It's denied.
Denied!
What grounds?
Fuck you! Denied because fuck you, that's why.
Stated that I'm not going to do it again.
No, the judge should not say that.
Here for quite some time, and it's not that I'm losing my patience, but you're wasting the time of everyone in this court who should be doing their work.
I agree with you. I should have not been coerced into coming here.
Enough. Do you want to have a trial or not? I can very well make a ruling. If you do not want to continue, if you're done with your cross-examination, then you're done with your cross-examination, and I'll allow you the opportunity to testify.
I asked Judge Freya about was this matter civil or criminal? She stated it was civil. I requested a trial by jury in this matter. She denied.
Yes.
Why was I denied a trial by jury?
Why do you think? Because it's a goddamn traffic incident!
Can you show me where you're entitled to a trial by jury on a traffic ticket?
On the traffic, again, there's no evidence of this code applicable to me.
Because you are special?
No, sir, that I'm referring to the controversy.
What's the controversy?
Mr. Dennett here alleging me of violating
Officer Dene.
a code, right? Or law?
Traffic law.
Okay, a law. Okay. Now, since I haven't been provided with any evidence of that applicable to me, again, this is a question of jurisdiction.
You're making the determination on your own. The judge has already made the determination.
You're not going to do this again, are you? Because I'm ordering not to read or tell me things you've already told me.
Taco Josh Gaming, thank you for upgrading to Sovereign membership, and for the $5 super chat, Artie, you are only missing a baseball bat for my anime schoolboy costume. Rock on, good sir. Okay, I'm not cosplaying right now, okay? It's Star Wars Day. It's May the 4th, so I have a Stormtrooper hat and a little pin, and I'm wearing my Rebel Crest silk tie, good sir. Anyway.
6 or 7 times, and I've read your motions twice now.
Why is my right to a trial by jury is denied?
You don't have a right to a trial by jury. It's not that it's denied. You don't have one.
I don't have one. So you never gave an oath to support and uphold the Constitution of the state and United States of America.
That's not true.
Okay, he's about to go into a misinterpretation, misapplication of the Seventh Amendment.
You don't.
Which, by the way, has not been incorporated like the other amendments. I keep forgetting this, but it's one of the very few amendments that has not been incorporated. With that being said, most of the states have, of their own volition, held a right to trial by jury in civil cases, but they define what criteria is needed before that right is applied.
Cross-examine me, cross-examine the witness if you wish to continue. Otherwise, this trial is over.
Sir, you just stated that I don't have that right.
Stated. Do you want to continue or not?
I was trying to continue. You denied my right right now.
Fine. Do you want to continue or not? I'm
want.
not denying anything. You continue your cross, but do not ask me any more questions.
I want a trial by jury in this case.
Denied.
Denied on what grounds?
You don't have a right to one.
Yes, I do.
Yeah, where does it say you have a right to trial?
U.S. Constitution, Bill of Rights, Article 7, in suits of common law where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact.
Now, of course, this is not, a traffic ticket is not a controversy over money. So this is where the SOVCITs misinterpret the Seventh Amendment. Seventh Amendment is federal, and it applies to civil proceedings where there's a controversy of, somebody owes somebody something. a traffic infraction is a low-level crime, and it's run by the rules of criminal procedure. And it's not an issue of somebody owes me money. It's an issue of was a law violated or not.
Tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law.
Okay. Very good. I get your point, and you can appeal my ruling.
Okay.
I really understand where you're going with this, but you don't have to keep repeating it.
See, that's the one thing. That's the other thing that Juan doesn't mention. This guy, it doesn't matter whether the judge says, "Okay, I understand your argument. I don't agree with it. I'm making my ruling. Move on." He is not moving on, and it's killing me inside.
I really do understand what you're saying.
Well, so if you understand what you're saying and
I
you
don't
deny
agree
my...
with it. Just because I understand it doesn't mean I agree with it. So, again, and for the last time, continue your cross-examination, testify, or we're going to draw an end to this trial. Those are your three choices, and do not follow this up by asking me a question.
Sir, I feel threatened in this court by you because you threatened me earlier of contempt.
Very nice. Have I helped
You
you
also-
yet?
you
You've
also-
answered after my repeated warnings. So, if you're not going to take one of the three options, would you like me then to rely only on what I've heard so far? What you don't have is the right to stop court in the middle of court by your antics.
I'm not stopping the court.
Yes, so then proceed.
You being an attorney for a witness.
Proceed. Or don't.
You keep.
If you do not proceed with cross-examination, I will deem that you have waived the right to further cross-examination.
Sir, I would like to proceed with the
Do
cross-examination.
it.
You keep stopping me all the time.
I said do it. Proceed with a relevant question, and I will let you proceed.
Every-
Proceed with a question that is improper, and I will not.
Objection. Every question is proper and relevant
That's
to this
not
matter.
your ruling to me.
According to your opinion, the judge is well within his rights to determine what is and is not relevant, which, again, you can appeal if you want. Now move the fuck on!
That's not my ruling to make. So you already
It's not your ruling to make!
you've determined your ruling.
I've determined each of my rulings and the rulings I've made. Yes, of course.
Okay, so right now you pretty much know where this court is going, this trial or whatever.
I haven't heard the cross-examination, if you want to continue it, and I haven't heard your testimony.
Sir, I'm sorry, but how are you gonna hear the testimony of the officer and cross-examination if you're not letting me cross-examine the witness?
Continue with your cross-examination right now, or you will have waived the right to further cross-examination.
Okay, I'll continue. Are you familiar with police term testifying?
I'm sorry?
Are you familiar with police term testifying?
Test to lying?
Yep.
No, I'm not familiar with it.
You've never heard of such a common phrase in the legal and police profession?
Test-a-lying? What?
I have not.
It refers to the problem of rampant police
No,
perjury.
sir. You get to ask questions, not make statements. Cross-examination.
Okay, are you familiar what a Brady cop is?
OPT, I literally have never heard of that phrase before. I have not.
I'm sorry?
Are you familiar what a Brady cop is?
No.
Have you ever been dishonest on the job, whether in court or out?
I'm not going to answer that on the grounds that it has nothing to do with pertaining to this situation at hand.
You've already asked this question. You're always honest. Yes, he's always honest.
objection? Are you leading?
How is that leading? The judge didn't ask a question. How is that a leading objection? I am losing my fucking mind right now. I have not heard any of this second part. I was not prepared for this. I'm not even a trial attorney. I am not a trial attorney, and I'm losing my goddamn mind right now. Fuck and hell! God damn it!
By jury.
Can you show me where you're entitled to a trial by jury?
Sir, I feel threatened in this court by you.
Cross-examination right now, or you will have waived the right to further.
As part of my job, that is correct. As a police officer, yes. That's what I'm sworn to do.
Thank you. Do you arrest people you believe they have violated the code?
It depends on what code says.
No, it's a yes or no question.
No, it's not.
Yes, it is.
Sir, move on.
Okay,
There's
non-responsive.
no arrest in this case. It's not relevant. There's no arrest in this case.
Okay. I object to that too. And you're honest in your investigation of violation of the code?
I'm sorry, sir?
And are you honest in your investigations of violation of the code?
Of what code are you pertaining to?
Particularly in the one you alleging me of violating?
Am I honest on the code of the violation I issued the 2 summonses to you? Yes.
Congratulations, you fucking played yourself by asking a fucking stupid ass question. Why, yes, I do believe I'm being honest and credible about the 2 citations that I issued to you in this incident. Congratulations, you have the officer saying that as testimony under oath.
If there isn't sufficient evidence to prove a violation of the code, you would not issue a complaint against me?
I'm sorry, I don't understand the question.
If there isn't sufficient evidence to prove a violation of the code or law, would you not issue a complaint against me?
I'm sorry, but I still don't understand the question.
Sir, is the question
You're putting in a double negative.
whether he would, if he thought that there wasn't a sufficient violation, he wouldn't issue a ticket?
Let me try to rephrase
I
it.
think neither one of us understood it, so
Okay.
try again.
Let me separate in a few questions. Do you rely on evidence to prove the violation of the code and law?
That is correct.
Okay, so do you have to have sufficient evidence to prove that?
That is correct.
Okay, so if there isn't sufficient evidence to prove a violation of a code or law, would you not issue a complaint?
That would be correct.
Congratulations, you played yourself.
Do you hold an objective standard of proof?
To whom or what?
Do you know what the question means?
I'm thinking it's pertaining to him, but I'm not really
Well,
certain.
let's don't guess. What do you mean by that question, sir? Objective standard of proof. What does that mean?
Well, what I'm asking here is that Do you have standards? Do you have your own standards of proof that you rely on to present, that you're presenting in court against me in these allegations?
If I was to ask this question, which I wouldn't, I would not ask this question because it's fucking idiotic. I would be asking, are you trained to make determinations as to whether or not you believe a law has been violated in the state of New York?
Standard would be the summons I issued you.
So these standards, the standard of proof, you apply to everybody who you alleging of violation of a law and code?
I'm sorry, can you rephrase that? I don't understand a little better.
Yes, sir. So you just referred to a complaint that's being a standard of proof in a code and law violation, correct?
I still don't understand the question. I referred to your summonses issued to you and the day that I issued you them as a standard of proof.
Standard of proof.
Correct. I believe you got 2 copies the same day, correct?
No, I'm sorry, but I'm cross-examining the witness.
No problem.
I got that. I made that ruling, sir.
Now the judge said, rightfully, the witness can't ask the defendant the question. I will agree with the judge right there.
Were you the one who charged me with violation of the code? Correct?
Which code?
The one on accusatory instrument.
Are you
For
referring?
the record, I'm showing the officer the summonses.
No, I'm asking you, you probably,
Are you the
I understand what you're saying.
accusing officer?
Are you referring to Vehicle and Traffic Law 375-34 with your rear reverse light out and Vehicle and Traffic Law 375-12AB2 front driver and passenger side windows tinted? Is that what you're referring to?
I'm referring to the code. I don't know the code and I'm not enforcing it. So
You asked him. Let's go back to what you asked.
were you the one who charged me with violation of the code?
He asked, and he was wondering, I don't know what code you're referring to. Because there are 2 charges on the instrument.
Correct?
Showing the officer the summonses.
No, I'm asking you, you probably,
Are you the
I understand what you're saying.
accusing officer?
Are you referring to Vehicle
You keep saying the code. Which one?
and Traffic Law 375-34 with your rear reverse light out and Vehicle and Traffic Law 375-12AB2 front driver and passenger side windows tinted? Is that what you're referring to?
I'm referring to the code. I don't know the code and I'm not enforcing it. So I'm just asking.
Is he the officer who's accusing you? Is that your question?
Yes, if he's the one who's accusing me of violation of this code.
I am the officer accusing you of the violations of the summonses issued to you. Correct, on October 22nd of 2013.
Thank you. You determine on your own the code applies to me?
Okay, for those asking, there are... Oh god, there are about 15 minutes left. I'm sorry.
That is correct.
And you determine on your own I violated the code.
That is correct.
And are you certain I violated the code?
You will be operating the vehicle on the day that the summonses were issued, so yes.
So it's a yes answer, correct?
That's what I said at the end of my sentence.
Thank you.
That is what I said at the end of my sentence, asshole.
Are you qualified to determine on your own I violated the code?
Yes, I am.
Are you an expert in interpretation and application of the constitutional laws?
So that's not the question that you were asking. You were asking about the summonses that were issued to you. He doesn't have to be a constitutional expert.
Exactly. I would object.
In order to do.
Objection, relevance.
Okay, let me rephrase that. Are you an expert in interpretation of application of codes and laws?
Yes.
When you determined I was subject to the code, was it based on facts or was it arbitrary?
It was based on facts that what I observed.
Facts that he observed.
What facts do you rely on to prove the code is applicable to me?
It doesn't sound like there's a prosecutor at this trial, Carrie. It sounds like New York is one of those states where the officer is the only person that needs to be present for a traffic trial to occur. Again, that's not in every state. It's not New Jersey. But yes, it sounds to me that in New York, the officer, the only person that needs to be there is the officer who was the witness.
I'm sorry, say that again?
What facts do you rely on to prove the code is applicable to me?
Facts that you're operating a motor vehicle in New York State, so you're subjected to the vehicle and traffic law of New York.
You are operating a motor vehicle within the state of New York. Period. End of story. Thank you.
State, which you violated on that day.
And is there a factual connection between code and law and me?
I'm sorry, say.
What the fuck does that even...
The connection, the mere fact that he was operating a car, motor vehicle, automobile, whatever you want to call it, on the public roads. That's the nexus. That's the triggering event that makes him subject to those traffic laws.
Is there is factual connection between code, law, and myself?
I'm still not really understanding your question.
Yeah, which is exactly what I would be saying too. What the fuck does he even mean? Oh, come on! I didn't even click the goddamn...
Be a constitution.
8.
Yes.
Oh shit! I hope we're not going to go down this heretic.
Oh, no. Oh, what I missed! Shit! Oh, I'm so sorry. I'm so sorry, y'all.
Determine on your own I violated the code.
That is correct.
And are you certain I violated the code?
You operated the vehicle on the day that the summonses were issued, so yes.
So it's a yes answer, correct?
That's what I said at the end of my sentence.
Thank you. Are you qualified to determine on your own of the
Expert.
what facts do you rely on to prove the code is applicable to me?
New York State.
And is there a factual connection between code and law and me?
I'm sorry, say.
He just gave him the connection. The mere fact that he was operating a car, motor vehicle, automobile, whatever you want to call it, on the public roads. That's the nexus. That's the triggering event that makes him subject to those traffic laws.
Is there is factual connection between code, law, and myself?
I'm still not really understanding your question.
Real quick, Syed Ahmad, $3.99 super chat. There better be a tasing at the end of this video. Thank you very much for that super chat, Syed. Unfortunately, I don't think there is. I kind of wish there was at the end of this because he's getting me there. Kelly McDonald, $4.99 super chat. Thank you very much. How long is this allowed to go on? Your guess is as good as mine. Honestly, I would have found him in contempt like at least half an hour ago, if not longer.
Okay. Well, you answered a previous question. You rely on facts to prove.
Oh, I'm sorry. I almost missed this one too. Stephen Alley, $2 super chat. Here's a glass raised to the poor stenographer. I agree.
To prove the code applicable to me. So I'm asking if there's factual connection between the code and law and me.
If you were operating the motor vehicle the day that I observed your reverse light out and your tinted windows out, then yes, the code would be connected with you because you're the operator at the time.
Could you please clarify this only facts?
Please do my work for me and get me out of this ticket. Witness for the prosecution.
Clarify that.
The facts that you rely on.
What I observed.
So your observation is the fact that connects the laws and codes and me?
Correct.
Did you witness me within the state?
Yes.
Oh shit! I hope we're not going to go down this heretic type rabbit hole here.
You know we are, Juan. You know we are.
Is that an arbitrary opinion or is it based on facts currently within your knowledge?
I'm going to go out on a limb here and take judicial notice that the city of White Plains is within the boundaries of the state of New York.
I'm gonna pick. Yeah, the judge is like, I'm gonna take judicial notice and say that the city of White Plains is within the state of New York.
Now there's something that this Mr. Medvedev totally misses. The judge is taking judicial notice of the geographic
God damn it! I just made the point that Juan was gonna make.
location.
Get to know that me and Juan are in sync here.
Objection. Are you answering his question?
I'm making a ruling. Move on.
What is the state factually?
You don't have to answer that. It's a philosophical
What is the state?
question.
Objection.
Good. Move on.
And it is Mr. Jeheretic who likes to say you can't be in the plaintiff. Can't be. You can be in it if you're buried in the ground. You know, this type of stuff. They don't understand that it is a philosophical question and issue, what the state is.
So noted.
You're being unfair.
So noted.
I am the Senate.
Did you witness me committing a code violation?
Vehicle and traffic law code, yes.
Is that a crime?
Do it. I think both he himself and myself were I wasn't clicking a pen, but I just caught myself I noticed that I was doing this with this pen that I have. I don't know if that was what you heard. I know that he was doing the pen clicking himself, but I just noticed that it was registering in the mic, so I just like put it over here. Thank you, Mo Army 67 for the $5 tip. Much appreciated.
That is a vehicle and traffic law crime, correct?
How many elements are in this crime?
I'm sorry?
How many elements are in this crime?
How many elements are in the fact that you had a reverse light out and your windows were tinted?
See, this is the thing is traffic infractions are what's called strict liability crimes, if you will.
Exactly.
There's no intent, no state of mind, no mens rea element to it. There's basically two elements to strict liability, that there was a law and you were observed violating that law. Those are the two elements, a law and an action.
Is that what you're asking?
I'm just asking to determine, to respond to me how many elements are in this crime.
Can you define elements?
Stop, please stop. That's a legal question. It's not a factual question.
And why I cannot ask him a legal question if he's making legal
Because it's not
conclusions.
up to a witness
He's not. He's not making a legal conclusion.
to determine what the law is.
Well, he's the one who made a complaint against me. He's the one who determined, he just stated, he determined that code and law is applicable to me.
A determination is not the same as a conclusion.
Yes.
And why I can, so it's his legal conclusions.
Ah!
Factual statement, it's my conclusion whether it violated the law. Whether what he observed violated the law.
Okay. So is he not competent to answer that question?
I don't believe so. I don't think.
Are you competent in answering that question?
Sir,
Yes, sir.
it is up to the people to prove each and every element of an offense charged. Whether they've done so is a determination for the fact finder. In this case, I'm both the finder of the fact and the law. And so I will determine at the conclusion of the case whether his testimony satisfies the elements of the crime.
Let me understand this correct. He knows these facts, you know these facts, and I don't know these facts.
You really don't?
I'm asking you because you're the one who's making this ruling right now, and I'm the one who's trying to cross-examine the witness.
Continue. Your objection's noted.
All right, I'm finished.
We have the from Mr. Medvedev. Do you wish to testify?
Nope.
Well, in charge of violation of section 375-34. Which states, and these are the elements of the offense. Any motor vehicle may be equipped with, and every passenger vehicle registered in this state and manufactured or assembled after January 1st, 1969 shall be equipped with at least one backup light. Such light shall display a white light to the rear when the ignition switch is energized and reverse gear is engaged. Such light shall not be lighted when the motor vehicle is in forward motion. According to the testimony, your rear reverse light was not functioning. So I find you guilty of that charge. The other charge is 375-12A-B2. A of 375 is as follows. Every motor vehicle except a motorcycle when driven or operated upon a public highway, road, or street should be equipped with a front windshield in a fixed and more or less upright position, constructed of safety glass as defined in subdivision 14 of this section and required by subdivisions 11 and 12 hereof. No person shall drive any motor vehicle with any sign or other non-transparent material other than a certificate or paper required to be displayed by law upon the front windshield or the side wings or side windows on either side forward, or adjacent to the operator's seat. That's 375.12a. A, you're charged with violation of section 375.12a, A2, I believe. I'm sorry, B2. Subdivision B indicates no person shall operate any motor vehicle upon any public highway, road, or street. And referring to number 2, the side wings or side windows of which, on either side forward of or adjacent to the operator's seat are composed of, covered by, or treated with any material which has a light transmittance of less than 70%.
So I couldn't take it anymore, and it's obvious, but I can only assume that the judge is now making his ruling at this point.
The only testimony I've heard in that regard is that the officer couldn't see you. I don't believe there are sufficient facts for me to ascertain whether it was less than 70% that your windows were allowing through. So I'm finding you not guilty of that one.
So, despite all of his bullshit, the judge made the ruling that he's not guilty based on the officer's own testimony. Which should tell everybody here that the judge, notwithstanding this guy acting like a complete asshole, is following the law. He is making an objective ruling, at least with regards to that charge.
This is from 2013, the 10th month. 15. So with respect to your conviction of 375.34, and that's with respect to ticket number BD0823266.
So he was, I didn't hear it, but he was found guilty of the other charge. Okay.
Ticket, I'm sorry, that's correct. That's correct. And ticket BD0823292 is dismissed, not guilty after trial. All right, sir, just give me your name at the window and take care of the fine and surcharge, please.
Where do I get information about the appeal?
At the window.
At the window.
All right, Visa, MasterCard, Discover, or cash.
Thank you.
Okay, so this doofus wants to appeal. Now this case was so simple. He could have put a fucking light bulb in his backup light socket, and that would have been dismissed. He could have simply also said, Judge, there's no evidence, no proof that the tint on my windows meets that 70% threshold.
Exactly!
That would have been dismissed, and it was dismissed. So now he's got a ticket that exceeds way more than a backup light would have cost him. So anyway, I hope you enjoyed it. I hope you're not too drunk.
Seriously, why are you calling me out, Juan? Juan Galt is calling me the fuck out right now.
And if you like these type of videos, please like and subscribe.
Fuck. We're done. We're done.
When I, with my friends, take over, you go to Gulag.
You go to Gulag.
Somebody once told me the world is gonna roll me.
the matches. You'll never know if you don't go. You'll never shine if you don't blow.
I like how I've lost instantaneously like 30 viewers.
Game on, go play. Hey now, you're a rock star. Get the show on, get paid, and all that glitters is gold. Only shooting stars.
You have a Ushanka?
The mold. Bravo, Dello, 1 point, Dina, Trudina, Borgia, Mars, Fognovia.
All right. I wanted to end it partially on that note with Mr. Russian immigrant sovereign citizen, but yeah, leave me alone. I'm sorry. Was that an alternate universe where I became an incel? Oh, wow. God damn, Liz. Jesus. Wow. Fuck me. I was not prepared for that one. All right, so that was the end of that. I'd rather not subject to the rest of you guys who are watching, wanting to watch a trial to any more of my stupidity. I am probably inebriated enough that I'm just gonna have an after party afterwards, but I'm gonna end it right here. So those who care, those who wanna enjoy my stupid ass doing stupid things, you could do that. You could do that when I start the stream again. But I'm gonna stop it right here to end it on a note that, you know, you guys got to see my reaction, my analysis, my breakdown of the Sovset trial, which is a typical Marc Stevens bullshit. But I appreciate you guys coming in to watch. I appreciate all the support that I got throughout the stream. And for those of you who care to see me doing stupid shit, I will see you guys in about 10 minutes, if that. So, thank you guys again. Much appreciated. Adios.